What happens when someone walks into a courtroom and claims the entire justice system has no authority over them? Today's case isn't just another sovereign citizen meltdown, this one comes with a twist. Instead of the usual, "I'm a Moorish American," or "I don't consent," we're dealing with a self-proclaimed Israelite arguing that prosecutors have no power of attorney over him, that barcodes control legal identity, and that capital letters determine jurisdiction. Yes, you heard that right. Now here's where it gets interesting. The judge in this case is not confused, not intimidated, and definitely not entertaining pseudo-legal word salad. From the very first exchange, you can feel the tension building. The defendant wants dismissal based on theories that have zero grounding in actual constitutional law, while the court is focused on something much simpler: procedure, jurisdiction, and whether he plans to represent himself. But here's the real question. What happens when ideology collides with reality? When someone genuinely believes the court has no authority, yet they're physically sitting in front of that very court? And what happens when that same person later asks for bond reduction after previously refusing to acknowledge jurisdiction? Stick around, because this one escalates from bizarre legal theories to real consequences. Let's get into it.
Want to handle that case right now, Judge Najee Goodman? Mr. Bowditch has spoke to him.
Mr. Bowditch, are you ready on Goodman?
Well, Your Honor, I spoke with Mr. Goodman. Mr. Goodman asked me to tell you that the prosecutor in this case has no power of attorney over him. He's an Israelite. There's no grounds under the bar code this matter should be dismissed. I believe he may want to represent himself. You may ask for some clarification if you talk to Mr. Goodman, but that's what he told me to tell you.
Thank you. Mr. Goodman, are you requesting that you represent yourself on this matter? You're muted, Mr. Goodman.
What I'm saying is, nobody has power of attorney law over me through the barcode. I'm the beneficiary. My name is not those capital letters, so I'm an Israelite from the 12 tribes. So what I'm saying is I'm representing myself. That's all that needs to be said, because that's what the law is. I got common law jurisdiction. It's a non-violent crime. So I push for it to be dismissed under the barcode.
Well, it's not going to be dismissed today. So simple question. Are you representing yourself from this point forward? Yes or no?
Yes, I'm counseling myself.
All right. Mr. Bowditch, you're out. Thank you. I said, are you planning on filing a motion, or would you like to set this case for trial?
I'm planning on filing a motion to dismissal because there's no grounds or no standing over my case, because nobody has power of attorney law to hear me, to even take this process even further. You got to prove that first. You got to prove that you got power of attorney law over me to hear this matter. Okay, I'm an Israelite.
But you don't know what you're talking about.
I do know what I'm talking about. You don't have power of attorney law. The prosecutor don't have power of attorney law. You don't have power of attorney law. It's under the barcode.
Mr. Goodman, please do not interrupt me. I'm trying to be polite.
Okay, it's under the barcode though. This is what you signed up to do. You're a public servant. So
right, unless you are a price on a can of beans, we don't need a barcode.
Let's pause here for a second because this moment is critical. The defendant keeps repeating that the court must prove power of attorney over him and references something he calls the barcode. This is a common misunderstanding in certain sovereign-style belief systems, the idea that legal identity is tied to capitalization of names or commercial law concepts. But in actual criminal court, jurisdiction is established through statute and geography, not typography. When the judge says she doesn't need a barcode unless he's a price on a can of beans, she's making a key point. Criminal prosecution is not based on consent or contractual agreement. It's based on whether an alleged offense occurred within the court's territorial jurisdiction. That's it. Notice how the judge keeps steering the conversation back to one simple procedural question: are you representing yourself? She's not debating ideology. She's keeping it on record. Why? Because if he chooses to represent himself, that decision has legal consequences. Let me ask you, if you truly believed a court had no power over you, would you argue inside it? Or would you ignore it entirely? Think about that.
Got him!
Yes, I am. I'm a human being. I'm not a deity. I'm a human being. I'm a living man. I'm a living being. I'm not no cargo. I'm not none of that. It's under the barcode.
Okay.
This is the real law.
Come
You have
here.
no standing or no ground.
Mr. Goodman, I'm going to give you a date for your motion.
I'm
to
only
be
here to
heard.
threaten cohesion.
Pardon me?
I want all my rights intact to me at all times. Do you agree?
I can't understand what you're saying. I think you're too close to your mic.
I want all my rights intact to me at all times. Do you agree?
I can't understand you, so no, I don't agree. I hear you're something
Okay,
all the time, but I don't know what you're
all my
saying.
rights intact to me at all times. I want all.
I can't understand you. All right.
Okay.
Are you still living on border? Are you still living on border? Mr. Goodman, are you still living on border?
Ashley, keep yourself muted, please. Your child keeps crying. Thank you.
No, I live somewhere else. I moved.
All right. Can you give me that address, please?
I stay at hotel rooms from time to time because I don't have no house right now. So I've been staying in hotel rooms.
Geographically, where are you at today?
Detroit, Michigan.
All right. So my next pretrial date is when, Heather?
It is March 8th.
All right. So Mr. Goodman, I'm going to give you a date on March 8th to file a motion. You file a motion, we'll hear it on March 8th. That's going to be in person.
Motion for dismissal?
Whatever you want to file a motion. You said you wanted to file a motion. So I'm giving you a hearing date for your motion.
What time?
We'll schedule that at 10 a.m. and this is going to be live. No Zoom.
All right.
I'm having trouble
All right.
with the
I
audio.
want all my rights intact to me at all times.
Pardon
I'm
me?
only here to threaten. I just want all my rights intact to me at all times. And everybody just got to prove that they got power of attorney law.
You got to slow down because you're talking so fast I can't understand you. I keep hearing all time, but that's all I'm getting.
Okay, what I'm saying is for the dismissal, I'm about to put it in today. You got to prove that you got power of attorney law over me. I'm going to have to sue the courthouse for a 100-fold.
Mr. Goodman, I don't have to prove a damn thing to you, sir. If you're here on the
You got to prove
listen to your motion.
you got to prove that you got power of attorney law over me. You don't have power. I don't care what you're talking about.
Attorney over you, Mr. Goodman. Listen
Yes,
to
you
me.
do. You need power of attorney law to talk to me. You ain't got no
Listen to
ground.
me.
You ain't no standing. You ain't got no ground to understand it. I got the affidavit of truth right here. I got authenticate birth certificate. I got a letter of intent over here right now. I broke all my contracts with the government. I'm not those capital letters. I'm with the 12 tribes of Israel. My name is Israel. I'm an Israelite. I'm with the 12 tribes of Israel. You don't got no power of attorney law over me. I'm pushing for dismissal. I'm suing your courthouse for 100-fold.
And here's the predictable pivot. After insisting the court had no authority, after demanding dismissal and threatening lawsuits, he fails to appear, and now he's appearing from jail. This is where theory meets reality. Failure to appear is not a philosophical issue. It's procedural. When a court orders you to show up and you don't, a warrant follows. It doesn't matter whether you believe in common law jurisdiction or tribal sovereignty theories. The system responds to conduct, not belief. Now look at the shift in tone. Suddenly we're talking about bond amounts, GPS tether conditions, forensic evaluations, and domestic violence charges. These are tangible legal issues. The stakes are no longer abstract arguments about barcodes, they're about liberty. Also notice something important: even though the prosecutor is open to a personal bond with tether, the judge isn't persuaded. Why? History. Courts consider past behavior, especially prior failures to appear. Bond is about ensuring someone returns to court. If there's a pattern of non-compliance, judges tighten conditions. So here's the engagement question: should judges prioritize second chances, or patterns of behavior? What would you do if you were on that bench?
You.
Try it again, counsel. I'm sorry.
Good morning, Your Honor. Patricia Manning for the people, P84088.
All right. And Mr. Goodman, can you hear us okay?
Yes, sir.
All right. And Ms. Murphy, what are we doing on these files?
Judge, it's my understanding that Mr. Goodman has an appointment at the Forensic Center on January 31st. As Your Honor knows, he has pending cases in Frank Murphy. He went before Judge Michael Callahan yesterday. He was, his bond was reinstated with a tether. I believe Your Honor has put a 250, 10% bond on Mr. Goodman. You know, Your Honor, that I'm going to ask you to reduce that bond to something affordable.
All right, so I've got two files. One file's got that 250, 10% with a GPS tether. That would be the February 5, 2022 incident date. And then the other file, which is the misdemeanor file from May 10, 2019, he's just on a personal on that one with a GPS tether.
Right, and you know, Your Honor, that I don't represent him on the DV.
Right, right. But he finally does have a date for a forensic exam?
Yes, Judge.
Okay, all right. So you just want to adjourn the PCC?
Yes, Judge. And ask for a reduction in bond.
Thank you. And Mr. Goodman, have you talked to an attorney on the domestic violence case, or are you representing yourself on that one?
I have nobody to represent me. I think it was Langford or something was supposed to be my attorney. I'm not sure how it went south.
Okay. All right, counsel, go ahead and make your bond argument. But before you do, just so we're all on the same page, my notes say it's 25,000, 10%, no contact with complaining victim, and GPS tether. Is that your understanding?
So, Judge, I thought it was 250,000, 10%, 25,000.
I don't know what I just said, but
oh,
my file says 250. Well, yeah, 250,000, 10%. Correct.
So, Judge, I mean, obviously that's unaffordable. Mr. Goodman is not a man of me, and his significant other just acquired new housing, Your Honor. They have a baby. Mr. Goodman needs to be there to assist with childcare responsibilities because both of them were working before Mr. Goodman was taken into custody. I know we've had some issues, Your Honor, with appearing in court. Mr. Goodman has had transportation issues with respect to getting to the forensic center, and that was his issue, Judge. The tether violation was simply a malfunction of equipment. So I would ask Your Honor to, and since they do not have means, Your Honor, I would ask Your Honor to reduce the, I'm asking Your Honor for a personal with the tether.
Response.
And
counsel, you don't have to jump up to talk to me. I know it's instinctive, but it's okay if you don't.
thank you, Your Honor. It is instinctive. Your Honor, in this case, he is before us for a misdemeanor DV. I understand he does have some pending felonies. I understand he's on a GPS tether for the felonies. I believe at this time, the most important thing is that he remain on, or that if he is released, he remains on a GPS tether. So in this case, I would not object to a personal bond.
All right. Ms. Murphy, unfortunately, this is one of those situations where I don't care what the parties think, because I've got a long history. This building's got a long history with Mr. Goodman not showing up in court. So I set the bond for that reason. I'm keeping the bond as it is for that reason.
And here's the predictable pivot. After insisting the court had no authority, after demanding dismissal and threatening lawsuits, he fails to appear, and now he's appearing from jail. This is where theory meets reality. Failure to appear is not a philosophical issue. It's procedural. When a court orders you to show up and you don't, a warrant follows. It doesn't matter whether you believe in common law jurisdiction or tribal sovereignty theories. The system responds to conduct, not belief. Now look at the shift in tone. Suddenly we're talking about bond amounts, GPS tether conditions, forensic evaluations, and domestic violence charges. These are tangible legal issues. The stakes are no longer abstract arguments about barcodes, they're about liberty. Also notice something important: even though the prosecutor is open to a personal bond with tether, the judge isn't persuaded. Why? History. Courts consider past behavior, especially prior failures to appear. Bond is about ensuring someone returns to court. If there's a pattern of non-compliance, judges tighten conditions. So here's the engagement question: should judges prioritize second chances, or patterns of behavior? What would you do if you were on that bench?